Good morning. Today is March 20th, 2025, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Brandt?
Here.
Commissioner Ortiz?
Here.
Commissioner Wilson?
Here.
Chair Silver?
Here. Let's move on to item number one, and that's going to be public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? Go ahead, sir.
Yes, Chairman Silver. Sorry. Yes, Chairman Silver. I printed out 125 pages of a supposed response to an anonymous complaint about the city of Dixon. And I attended your last meeting where your chief enforcement officer was bragging about the number of cases he and his associates have closed. I'm not here to attack him, but I would like to help him and you. As you don't necessarily review the cases he has closed, and I'm very interested in one case involving the city of Dixon, I would like to bring this case to your attention. As the case has been supposedly closed, I don't believe my comments should prejudice your point of view on this specific case. As the case had a debatable decision and ending, I will not be discussing any aspect of my future complaint in regard to this individual or counsel which aids him in lining his pockets due to the network of bad old boys operating in Dixon and controlling our council. The first point is about the so-called warning letter issued to Mr. Johnson. The warning letter states that the Solano County DA, Krishna Abrams, did not give the FPPC permission to prosecute this case. I sent emails to confirm this to both the FPPC and Mrs. Abrams. Surprisingly, once that email went out, your staff stated they made an error, as Ms. Abrams had given you permission. I did not receive a response from the DA herself. My second point is now that your staff had permission, and given that they found Mr. Johnson had violated 1090, your staff still insisted they did not have enough evidence to prosecute. If they had enough evidence to find Mr. Johnson guilty, I would suggest your staff should have dug a little deeper. As a what if, let's say I put a bid in to lease Dixon's train station. I was not doing this for myself with the intent to allow a councilman to occupy the building, pay the rent, pay for maintenance, run his business out of the facility, sublease space to others, and all at a bargain basement price because the city refused to advertise this property outside of our own community. This councilman compensated me, acting as the overriding broker in some token way. But the bulk of the financial benefit is garnered by the fact he is paying a reduced amount in rent at a very well-known location. If your staff had looked at the relation between the leasing party and Mr. Johnson, it should have been easily been able to see this is a subterfuge. While the city attorney, Douglas White, did point out the exemptions in the code, his logic is flawed because of the actuality of benefit to Mr. Johnson. The point of the code is to prevent what is being allowed by your enforcement division's lack of prosecution and the subterfuge of allowing a figurehead to intervene for the actual financial beneficiary. I can and will destroy each of Mr. White's contentions in my coming complaint, and your legal staff should have been able to do the same with minimal effort. We have a council which never questions the city attorney's attempt to allow the unallowable. Common sense proves who is benefiting financially. To allow them to escape prosecution is a dereliction of your duty. Not only should Mr. Johnson have been fined, but none of these councilmen should ever be able to hold public office again as prescribed by Code 1090. It has been said that if you want anything done right, you need to do it yourself. I will be filing an additional complaint because this resolution is just not right. Otherwise, I will not be asking you, but I'll be asking myself, why are we even here? Thank you for your time.
Thank you for your comment. And, like I've mentioned in the past, always encourage the public to file complaints with the enforcement division. I appreciate you taking the time to do that. You've obviously really delved in the detail of the specific circumstance, so we really appreciate the time that you devoted to that. Also, just want to mention that, these rules are very, complex, something to consider. And I want to emphasize my confidence in the enforcement division. these rules are complex, but they understand the rules, and I think they do an excellent job, just in terms of having thoughtful analysis and thoughtful resolutions in these cases, as well as doing a great job getting through these in a timely and effective manner that really bolsters public trust and due process. So with that, thank you again for your comment, Commissioner Wilson.
Thank you, Chair, and appreciate the comments, public comments that were just made. And I know you've been to several of our meetings, but I want to be on the record as someone who's been on the FPPC since the end of 2019, that the staff does excellent work. They work long hours. Now, can you make the argument that we need more staff resources? That's not the issue here. But I think you have the right to bring your issues to the FPPC. But I want to go on record saying that the work that our staff does, working long hours and their dedication, is not the issue here. And to the extent they came to different conclusions, they shouldn't be, I don't want to use the word attacked, but strongly criticized when they do outstanding work. So thank you very much.
Any other public comment? Okay. Why don't we move on to item number 2, and that's going to be approval of our commission minutes from the February meeting. Any comments from commissioners, suggested edits to the minutes? Okay, hearing and seeing none. Any public comment on the February meeting minutes? Okay,
Motion to approve the February 2025 Commission meeting.
excellent. Second, Ms. Vo? Oh, you said.
That's fine.
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Let's move on to our consent calendar. So we have one item on our consent calendar this month. That's going to be item number 3. Do any commissioners have comments related to the item on the consent calendar? Commissioner Wilson?
I'd like to remove that item from consent.
Are you planning on, so I think it'd be good for, why don't our general counsel kind of speak to the process of removing something from the consent calendar versus leaving it on there for comment.
Yeah, Dave Bainbridge, General Counsel. Since it's the only item on consent, it doesn't really matter. So if you want to just discuss it, you can. There's no reason to pull it.
Okay, I was looking for the directive to allow us to at least discuss this issue. But we could leave it on consent as long as we can have a brief discussion.
Go ahead, Commissioner Wilson.
Yes, I just want to go on the record to say that the analysis provided by enforcement was very detailed and very clear. And I'm not raising any issues in that context, but I think it's important, given that it's a 1090 violation, to go on the record outlining the seriousness of the allegations and conclusions that were reached by enforcement. First of all, I just have one question, and it's not to question what's in the stipulation, but you have an elected official, the respondent, who was on the Newark School Board for at least a couple of years. So it's my assumption that she would have had to file a Form 700. Is that correct, or would she have been exempt for some particular reason?
Good morning.
Hi,
Thank you.
good morning.
Chair and Commissioners. I'm Angela Brereton. I'm the
Yes.
Assistant Chief in Enforcement.
And I'm Chris Burton, also Assistant Chief of Enforcement. Nice to see you.
Okay, nice to meet you.
So typically, a person of this, in this office would file Form 700s. Our investigation determined that she didn't. That's not up for an issue here. We did not receive a referral from the filing officer for this. This particular matter wouldn't have been, this interest wouldn't have been disclosable on a Form 700 anyway, because of the definition of income under the Act and the timing. So that would be something for us to look into in a different matter. But that's the background here. And we do state that she didn't file Form 700s.
Yes, so Council Brereton, there's no question that that's been clearly outlined. And I know that, and correct me if I'm wrong, that there was a reference by the respondent that she didn't have any knowledge of the FPPC or what its functions were. Is that an accurate
Yes.
restatement? Okay. So when I look at the timeline, to me, the penalty is more than justified. But you have an individual who, as you so clearly outlined, was on the Newark School Board, and at the same time, she applied for a position as executive assistant to the superintendent or to the school board. So I just want to go on the record that when you look at the facts that are clearly delineated in the stipulation, this fine is more than justified. And given that it's a 1090 violation, I just think it was important to highlight these egregious acts in public. So that's all I wanted to comment on.
Okay, great. Thank you, Commissioner Wilson. And I agree with Commissioner Wilson on those points. This is one of the most serious violations of the act, and I think the Enforcement Division did a good job responding to the direction that the Commission provided earlier this year when we emphasized that fact. So thank you again. Any additional comment on this matter, or on the consent calendar matter?
No, thank you.
Great. Any public comment on the consent calendar? Okay, then I'm going to move to approve the consent calendar.
Second.
Okay, Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson.
Aye.
Chair Silver.
Aye.
Motion passes.
Thank you.
Thanks.
Excellent. Let's move on to item number 4 from our general items. That's going to be adoption of proposed regulation 18720, annual statements of economic interest, 2025 filing date extension. And presenting us is going to be Commission Counsel Simon Russell. Good morning, Mr. Russell.
Good morning, Commissioners. Simon Russell, Commission Counsel. Good morning, Commissioners. Simon Russell, Commission Counsel. Glad you can hear me now. So this morning, I am presenting to you proposed regulation 18720 for your vote and hopefully your adoption. At its January meeting, this commission had asked staff to prepare a draft regulation that would extend the Form 700 filing deadline for officials impacted by the recent wildfires in Southern California. Now, this is not without precedent. Almost exactly 5 years ago, this commission did a very similar thing when we extended the Form 700 filing deadline in response to the COVID-19 lockdown. As a brief refresher, a Form 700 is a form that officials file at several points listing their financial assets that could potentially form the basis of a conflict of interest for them. They are required to file these forms within 30 days of assuming office, within 30 days of leaving office, and on an annual basis while they're in office. Now, the deadline for filing the assuming and leaving office forms is set by the legislature via statute, but the deadline for officials to file their annual forms are set by you via regulation, and that's the deadline that we're talking about today in this proposed regulation. Usually that deadline falls on or around April 1 for most officials. There's a very small subset of state officials who have to file by March 1. Just last month, the governor issued an executive order extending by 60 days the deadline for officials to file their assuming and leaving office forms. Those are the deadlines that are set by the legislature. He extended those for Los Angeles County officials because that's where the epicenter of the wildfires were. The draft regulation before you today would essentially do the same thing, but for the annual filing deadline. So we'd be harmonizing the annual filing deadline for LA County officials with the extension that the governor just granted to those same officials for their assuming and leaving office forms. Specifically, we would be setting the deadline to June 2, which is a Monday. So basically 60 days from what the deadline otherwise would be. If you do approve this regulation today, we could get it enacted before April 1, which would otherwise be the deadline. With that, I'll turn it over to you for your vote, but I'm happy to answer any remaining questions that you might have.
Move adoption of proposed regulation 18720.
Second.
Commissioner Brandt? Oh, sorry.
So we need public comment, really quickly before we go ahead and vote. Just because I think this is the appropriate time to do it rather than after we vote, is I just want to compliment the legal division on the way they handled this. So this is a very complicated situation. Obviously, nobody knew that the fires were going to spark up the way that they did and be so devastating. And we're talking about 16,000 structures were destroyed as part of the Eaton and Palisades fires. And that's not even including the fires in, the greater LA area like Ventura. You had 28 combined casualties. So this is something that we had to move quickly on and work with all different stakeholders. And legal division worked with the governor's office, our education division worked with the governor's office, other stakeholders, officials in LA County. And this was an excellent job by all of you. I really appreciate, as a former Los Angelino, that our agency has been so responsive when the city's going through something like this. One additional item here is, we've mentioned this before, at least myself, I would prefer that in the future that the legislature give us specific criteria to consider in making these sorts of extensions, taking this sort of action, right? So I'm hoping that legislature, if you're listening, perhaps that's something that could be considered and ultimately adopted, so that in the future, if something like this happens, we know specifically what the intent of the people of California is in terms of providing these extensions.
Good idea.
So with that, any public comment? Okay, hearing and seeing none, we have a motion, we have a second, so Ms. Vo?
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Motion passes.
Thank you.
Thank you. Okay, item number 5, and that's gonna be adoption of proposed repeal and amendment of the Levine Act. Did I get that correct, Commissioner Wilson? The Levine Act, section 84308. Regulations and related regulations. And we're gonna be hearing a presentation today from Commission Counsel Torrin Lewis and Senior Commission Counsel Kevin Cornwall. Good morning.
Good morning, Chair and Commissioners. My colleague, Mr. Lewis, and I are here to present proposed amendments to regulations relating to Section 84308, also referred to as the Levine Act. Thank you, Commissioner Wilson, for the Commission's consideration and potential adoption. So we discussed most of these proposed amendments at the January Commission meeting, but I'd like to reiterate some background information briefly just to provide context for the proposed amendments. So Section 84308, commonly referred to as the Levine Act, it establishes certain restrictions and requirements relating to contributions when a public official is involved in a license, permit, or other entitlement for use proceeding. So generally, it prohibits a public official from taking part in such a proceeding if they've received contributions exceeding a certain amount from a party or participant in the proceeding within the past 12 months. Parties and participants are similarly prohibited from contributing, and public officials are prohibited from soliciting, directing, or accepting a contribution exceeding that amount during a 12-month period while the proceeding is pending, before that official's agency, and for 12 months after a final decision is made. Section 84308 contains various other provisions, including some relating to disclosure of contributions and the return of contributions by a public official. Section 84308 was significantly amended, effective 2023, by SB 1439, which applied the statute to local officials for the first time when they had previously been exempt from the statute's scope. So the Commission made various regulatory amendments that same year. And then last year, Section 84308 was amended by two bills, SB 1181 and SB 1243. These bills eventually became companion bills, and they amended the statute in several ways, including raising the contribution limit from $250 to $500 and carving out new exemptions from the statute's scope, such as for contracts under $50,000 and contracts between agencies. Ultimately, the goal of the bills was to solve implementation issues associated with SB 1439 and the application of Section 84308 to local officials, including a purported chilling effect on political participation. Today, we're presenting proposed regulatory amendments, which were initially presented for pre-notice discussion at the January Commission meeting. And since then, we've taken the feedback that we've received from both the Commission and the regulated community into consideration and have made some further updates to the proposed language. So Mr. Lewis and I will go through each of these regulations, provide a brief summary of the proposed amendments, and address any related feedback that we've received and or incorporated. So beginning first with Regulation 18438 that pertains to general application of Government Code Section 84308. And with this amendment, we are clarifying that amendments to Section 84308 apply prospectively and that the relevant timeline for applying the statute is when the governmental decision or conduct at issue occurred, rather than simply when the proceeding was initiated. So to provide an example, say a public official received a $300 contribution from a party in an entitlement for use proceeding in 2024. This amendment would clarify that they could take part in that proceeding beginning January 1st, 2025, now that the relevant contribution limit is $500 rather than $250. And this amendment was added per the request for clarification by Cal Cities and LA County. Are there any questions related to this regulation?
Commissioner Brandt?
Yes, you mean for everything or not this? Okay. So I want to understand how you look at legislative intent. So I mean, in other words, and particularly on the particular issue that raised by Common Cause, and I want to understand how you think through those kinds of things. Have you? And I'm assuming you do, but I come from the legislature. That's why I'm just trying to understand how you do it, how agency does it. Have you looked at intent on the question of whether we delete the regulation on competitively bid because the language is? So I want to understand how much you understand or how much you've looked at or how much you've heard about what the intent of the statute adding detail and what kind of how you go about that and why we so let's start there. I will get to your opinion of what Common Cause has to say, but I know that kind of from experience that kind of sometimes you rely on regulations that they're there and you may not say anything, but is there anything that gives us a sense of why the legislature added the additional definitions?
And before you respond to that, that's a great question. And, that's something I think would be helpful for the public to be aware of as well. Why don't you provide an introduction of the issue that Commissioner Brandt is addressing? So, and I think 18438.2, and then we'll delve into the different public comment we received.
Yeah. So with Regulation 18438.2, and that is titled Proceedings under Government Code Section 84308, we made various proposed amendments. One, clarifying that the entitlement for use proceeding can be initiated by an action by an agency that implicates or targets a party or a limited number of parties. We also removed language codifying or otherwise addressing amendments to Section 84308, such as the definition of pending, which was codified with a slight modification by the legislation. And then with respect to competitively bid contract, currently our regulation provides a fairly specific definition of what a competitively bid contract, what constitutes a competitively bid contract. And that's because previously, the Section 84308 exempted certain competitively bid contracts, but it didn't make any attempt to define that term. So initially, with our first round of regulations, we came up with a definition to include in 18438.2, and that basically came from looking at a variety of sources. There isn't one specific definition of competitively bid contract. There are certain commonalities between how that term is used in different contexts. So for example, the Public Contract Code might have a definition for a competitively bid contract or some of the related terms in the context of construction contracts, whereas there might be a slightly different definition in the context of education contracts or contracts involving a federal grant. So initially, we were coming up with a definition that we thought would generally encompass most of what was meant by the term competitively bid contract. So in doing so, there were a couple hiccups, I guess, in things that we overlooked in our initial definition. So for example, our definition currently refers to the lowest responsible, or a responsible bidder with the lowest responsive bid. And so that didn't address the context of, say, a local agency is selling land. Obviously, in that context, you would want to award the contract to the highest bidder. And so we had given an advice letter kind of saying that interpretation was consistent with our intent with the regulation. We also encountered some questions about the language referring to, in our regulation, referring to required by law, whereas some jurisdictions have a competitively bid contract. It's more of a policy or rule and not necessarily in their city code or any sort of ordinance. And so initially, getting to the legislative history of the most recent bills, initially SB 1181 by Senator Glazier, that was drafted to address those specific instances or those specific issues with our drafting of the regulation. So the initial language that was included in SB 1181 referred to, rather than simply required by law, it referred to required by law or agency policy or agency rule. So that took care of that problem. It also referred to contracts that are awarded to the highest or lowest bidder, and that addressed that problem. And so the language at one point read, sorry if I don't get this exactly right, but it essentially would have required that a competitively bid contract must be required to be awarded to the lowest to the responsible bidder with the lowest responsive bid. And that language was consistent with those corrections with the regulation that we had at the time. Then that proposed language in the bills was subsequently amended to the more general language that is now in the law, which refers to that it requires that it be awarded pursuant to a competitive process. And so that's the general history of the statutory language. But I'm sorry if that begins to answer your question, but do you have any more specific?
Yeah, this is where I want to understand. So they were responding in some ways to our regulation, by putting in statutory language, but they don't have the lowest or highest or any of those things. They just have it. And so then the common cause raised the issue of, what about they go through a competitive bid, but they say, oh, but we like this one. And so that I'm trying to understand is, would our regulations be inconsistent with this, with the current regulations? In other words, the way we had it, would it be inconsistent with this statutory language? Would it just be additional?
It would be inconsistent, at least to the extent that it specifically refers to required by law or awarding to the lowest bidder. But I'm sorry.
So common cause raises the issue of, it goes through a competitive process, but then they choose, oh, but we like this guy.
Yeah.
That kind of thing. And so, and it's taken, the language takes out the highest or lowest, that concept.
Right.
It just says a competitive process. So, I'm trying to understand, does this language bar us from saying it has to be competitive and they have to take the lowest or highest bidder?
I think it does bar us. I think the legislative history both the language and the legislative history bar us from restricting it to simply the lowest or highest relevant bid. With respect to the specific examples provided by Common Cause, I think that those are, respectfully, I don't think that they're necessarily founded, given that the statutory language would already address the scenarios that they raise. So in both of those jurisdictions that they point to the local ordinance, and they say that, well, they have this competitive process, but ultimately they have this catch-all provision that allows them to essentially disregard their competitive process if they deem that it's in the best interest of their jurisdiction. And so right now, the statutory language refers to a competitively bid contract as one that is required to be awarded pursuant to a competitive process. So if we were to receive a request for advice asking, does this scenario that Common Cause has raised, does this meet the criteria of the statutory language? I believe our advice would be no, it does not, because in those instances, the contract is not required to be awarded pursuant to a competitive process.
Okay, so when we're reading an exemption, exemptions are read narrowly, and so therefore, when it exempts competitively bid contracts that are required by law, agency policy, or agency rule to be awarded pursuant to a competitive process, those situations that they identify would not be considered a competitive process? Is that what you're? I mean, if you talked about what you just said about the advice letter, I'm just trying to understand. We're narrowing, this is an exemption. Those processes may not meet the terms of that exemption as the statute reads now.
I'm sorry, could you?
The situations identified by Common Cause, would those meet meet the requirements of this exemption?
No, because although there might ostensibly be a competitive process in place that the jurisdiction has the opportunity or choice to use, in those particular examples, the jurisdiction is not required by law or agency policy to be awarded pursuant to a competitive process. So in those examples, no, it wouldn't meet that exemption.
Okay, so I can understand this because the way we treat exemptions are read narrowly. Law requires reading exemptions narrowly. I'm okay with the recommendation on this point because of now that I understand what the intention was and how they were responding to us in some ways, and providing the statutory language that's more definitive. Yes.
Can I ask a question?
Mm.
Of course.
Thank you.
Commissioner Ortiz.
Thank you.
And thank you for those comments.
Yeah, that was very good.
Excellent.
You helped me
Thank you,
think.
Mr. Cornwall.
So that I understand what the future application will be agencies, whatever, are required to have a competitive process. No longer the low bidding responsible bidder, or whatever those words are. How would they then how would they choose the bidder in a competitive process? It's just what is beneficial to the agency or to who,
I think that the legislative history and intent indicates a wider amount of deference to local agencies in determining, what constitutes a competitive process. Like I said, that there would be instances in jurisdictions where a competitive process is completely discretionary, in which case that wouldn't meet the exemption. But like I mentioned before, there are multiple definitions and different contexts in which the term competitively bid contract is used. And so they're not all going to neatly fit into sort of a one-size-fits-all definition. I think that there are other jurisdictions, for example, that they might have a competitive process or ordinances specifically dealing with competitively bid contracts, but say they have provisions relating to giving additional consideration to a local business that's owned by a woman or a minority or a veteran, in which case there might be some ambiguity as to, okay, is this person or this business constitute the lowest responsible bidder, which our current narrow definition wouldn't really encompass those types of situations. So a local agency would be able to establish, criteria for what it deems a competitive process. But I think that ultimately, if it came to us for, they were trying to ask us, does this constitute a competitive process? It would be a fact-specific inquiry, in the same way that, many other terms, we deal with via formal advice.
So do agencies have to take action to establish guidelines for competitive process?
Could you
Do
expand on that?
agencies, do they have to establish criteria? Let's say I'm an agency and I put out a contract,
Yeah.
a competitive, go through a process. Do I, as an agency, have to decide or regulate what goes into competitive contracts so that an applicant can understand what's going on? Because at this point, it's going to be discretionary.
Yeah, that's a good question. Is there a default that jurisdictions defer to, or are they required to adopt their own policy?
It depends on the context. So, for example, there are certain state laws that apply to local jurisdictions with respect to like public works contracts. But then there are another set of rules that apply with respect to education, schools or community colleges or colleges. And so there's different sets of rules and different competitive processes that a jurisdiction might have. And then a jurisdiction in other contexts, like for example, the context that Common Cause provided with the city of Alhambra, that was a specific ordinance relating to contracts specifically with consultants. So these are already ordinances that essentially I imagine every local jurisdiction is going to have, at least at the like city or county level. Competitive processes are already established. It's just that they may vary compared to the definition that we currently have in place under our regulation.
Okay, thank you.
Mr. Chairman.
Commissioner Brandt?
So I just want to clarify, because I just heard you say the statutory language is broader. I hear that, but I want to be, the staff is going to, and council is going to interpret these situations. I know we can't figure out all the things, but you're interpreting, you're following the law that statutory exemptions are read narrowly. So that is how, and I'd kind of like to hear from council, that you will continue to read it narrowly.
Yes, I agree with what you are saying, and we read exceptions narrowly.
Thank you. I'm good.
So I think what I'm struggling with here is that we have two competing realities, right? We have, based on the public comment, it sounds like the regulated community, they want direction, right? They want clarification so that they could more easily advise public officials on how to comply with this rule. Sounds like to a certain extent, good government groups want that as well. And then the intent of the bill that I saw in all the legislative history was, we want to make this conflict of interest provision, quote unquote, workable, right? And what I see that as, when I see that, I think we want to make it so it's easy to advise our clients on. And so there isn't inadvertent violations, right? So we have that one competing reality, at least in my opinion. Then we have another competing reality, which is that we have a regulation on the books that conflicts with the statute, right? And at least in my opinion, I'm looking at a regulation that says you have to accept the lowest bid. It's clear from the legislative history that at least one of the examples that they wanted this to cover would be land transactions where a city or a jurisdiction is required to accept the highest bid. Sounds like we might have had an advice letter on that. I don't think that's the best way to do policy, to just have an advice letter sitting out there when we should have it in a reg, especially when it conflicts with legislative history. So I'm looking for a middle ground that we can satisfy what I think is the chief legislative intent of this bill, which is to make this law workable, right, without violating statutory principles,
Yep.
legislative analysis, right? So my thought, and I'm interested to hear what commissioners think about this, I would encourage the stakeholders who've already worked with us, which I think is great. And I want to thank Cal Cities again. I want to thank County of Los Angeles, in Common Cause, and everybody else who's provided us with feedback on this topic for engaging with us, right? I'm hoping we can get additional feedback so we can get an idea of whether there is a universe of competitively bid contracts, I should say, a universe of processes that would fall under a competitive process that we can put into a regulation. It's very possible that there's just so many processes across the state of California in all these different contexts that we can't. But I want to see if it's possible. So I guess my hope is that following this meeting, and I'm just so we're all on the same page, my feeling is that we follow council's recommendation and that we remove the definition of competitive bid contract, because I don't think it's consistent with legislative intent, right? I'm hoping that once that's removed, we start a process where we reach out to the regulated community reaches out to us with examples of these types of processes so we can understand the universe, and then adopt a regulation if that's appropriate and consistent with the legislative intent. Okay.
And if I could just add that, for any agency that is proactively reaching out to us, just, providing additional context on, potential wrinkles in terms of how their competitive process might differ from the definition that we currently have in place or, used to have in place, that would be very helpful.
Perfect. And I know this was the one issue we received the most public comment on. So I think what makes sense here is we open it up for public comment just in case there's anybody on the line or in the room who has any comment. Unless the commissioner has a comment. Executive Director West. Okay. Commissioner Wilson.
No, I was just going to say I agree with the prior comments that were made, and with hundreds and hundreds of elected officials throughout the state. I mean, it's important that whatever we do is consistent with legislative intent. And I know that that's what you're working for, and we're all on the same page in that regard. And I think the answer is pretty clear, but this would also apply to school board members as well, correct? And a lot of those school board members are, they're part-time, they're not full-time employees. So I think it's important to also communicate with the city attorneys to make sure that they're knowledgeable, and given the excellent outreach and training that we do, every city attorney should be analyzing this issue, because there have been several iterations of this legislation that somebody may have not even realized that there was another bill passed. So thank you.
Commissioner Ortiz?
I agree with Commissioner Wilson, but it's not only city attorneys, there are tons of agencies. I mean, I was at AC Transit Board and we went through the low bidding contract and they're not gonna know that these things change. So communication is gonna be a very important tool to deal with this.
Yeah.
Thank you.
Thank you. We have any public comment? Okay. Go ahead. Good morning.
Hello, yes. This is Sean McMorris with California Common Cause. I appreciate this discussion and I want to thank the commission and commission staff for all of their hard work on these regulations, and commission staff was also responsive to my inquiries. So I really appreciate that. Listening to the discussion here, I just wanted to note a couple of things. So I think right now the assumption is that, or the definition of competitively bid is now defined directly in the law. I would argue it's not. The definitions of party, precedent, agency, officer, contribution, and pending are the definitions that are defined in the law. Competitively bid and the new term competitive process are utilized in reference to what is exempt in a license, permit, or entitlement. So just similarly to how competitively bid was not defined in the original Levine Act, and therefore needed to be defined in the regulations, I believe that standard still applies here. And certainly now that we have a new word, competitive process, which, as we outlined in our letter, really opens the door for potentially an end run around the Levine Act, particularly like in the city of Alhambra, where they don't just have an exemption clause that makes it discretionary, but they actually say in their code, price does not have to be the determining factor in how we choose our competitive bids. And we really worry that if you don't have a minimum standard where price is involved, you really open up the door for opportunities of corruption. And I just note that a grand jury that convened on the recent scandals in Oakland came to the conclusion that a competitive process was not defined and not undertaken. So, and on that point, I think that the definition is still important. And having been part of the negotiations in this language, the intent was certainly not to leave the door open to a jurisdiction to essentially decide themselves what competitive meant, which could possibly be very uncompetitive or competitive in name only because we accepted bids. And I note that the current definition doesn't account for the highest bidder, which was in kind of where this compromise language came in from my recollection. So I think that the current definition could be tweaked to include the highest or lowest bidder given the circumstances, and that would maintain that minimum baseline and give jurisdictions a lot more understanding about what they need to do if their code doesn't utilize price as a minimum standard. So I think those are, let me see, I'm checking my notes, I'm apologizing. And I just also wanted to make the point that this, by defining competitively bid, you're not prohibiting jurisdictions in any way from doing a competitive process and going about the way they say that process should be undertaken in their code or be a policy. They can still do that. It's just that if it doesn't adhere to a minimum standard, they're going to be subject to the Levine Act. And so we're not prohibiting any jurisdiction from doing what they want. So I just wanted to make that point. But I do appreciate the conversation, and hopefully that all of this can get resolved. And I do appreciate the staff saying that in the instance where a law or policy makes something discretionary, that they will likely be advising that that is not a competitive bid. Again, thank you, and I'll go now.
Thank you, Mr. McMorris, and I really appreciate your feedback and specifying that last item, that this wouldn't prohibit decisions, right? It would just narrow the exception, or I guess expand the exception to a certain extent, however you want to characterize it. I personally think that the FPPC is at its best when it's working lockstep with Common Cause, and that's why we're putting so much weight on the comment and feedback you provided, and I expect to continue doing so as we work through this process to find the best path forward. So thank you again. I'm really hoping that you keep engaging with the regulated community and us, so we can see if there's a solution here to make this more workable and also not allow for potential workarounds when you're talking about conflicts of interest like 84308. Commissioner Brandt?
I'm going to respond because the exception is going to be read narrowly for now, and that may lead to us figuring out, and there may be another way to deal with the regulation. But I would encourage you, and I appreciate your appreciation of that, that the competitive process is read narrowly. But I think that we need you, Common Cause, to help us work through what that is. And if we're going to achieve what the legislative intent is to make it workable, then let's figure that out. But for now, I think we take it out. And I think that's kind of where I think that makes sense. But this is something that I'm comfortable because I know what reading narrowly means. But I think if there's other ways, if you have other ways that we can get to what read narrowly means, I'm good with that, and I want to hear that. But I think you need to work with regulated community and others to make this workable.
Thank you, Commissioner. Any additional public comment? Okay. Well, then why don't we move on to the additional provisions of the proposed regulations?
Good morning. Moving on to proposed amendments, or rather the proposed repeal of Regulation 18438.3. This is a regulation that currently defines agent under Government Code Section 84308. And the reason for the proposed repeal of this regulation is that this term is now defined in new subdivision H of Section 84308, more or less precisely as it was in the regulation. So for that simple reason, we're recommending repeal of the full regulation.
Excellent, thank you. You can continue.
And then with Regulation 18438.4, which pertains to participant. Sorry about that. With Regulation 18438.4, which pertains to participants under Section 84308, the proposed amendments clarify and direct the regulated community to the relevant standards for determining whether a business entity or nonprofit organization has a financial interest in the proceeding. And this is because the statute, Section 84308, directs that a participant's financial interest is based on the Act's conflict of interest provisions. So with this amendment, we're simply directing the regulated community to the relevant standards for business entities and nonprofits, which may not otherwise be immediately apparent just based on where it's located within our regulations. And then with Regulation 18438.5, that pertains to aggregation of contributions under Government Code Section 84308. And we are removing language referring to the aggregation of contributions by agents based on statutory amendments to Section 84308, which now specifically states that contributions by agents are not aggregated with contributions by parties and participants.
Okay, moving on to regulation 18438.6, and this is a regulation that concerns the solicitation, direction, and receipt of contributions under section 84308. So basically, this just defines when a person makes, accepts, or receives a contribution. And presently, the definition doesn't include when a person receives a contribution to their state or county central committee. We have received advice requests on this question and have advised that a contribution to a county or central, state or county central committee rather, would fall under this regulation. And for that simple reason, we've added a clarifying change stating that. Let Kevin discuss the next one.
So I think you got to turn off one of your mics when the other person's talking, just you're going to get feedback.
Gotcha.
Commissioner Ortiz?
Thank you. Regarding point 6, because I remember raising this issue at the last commission meeting. What it needs to be clear, it is contributions as a member of the central committee when you are elected to an office outside. Because right now, if I read this and I'm a member of the central committee, I think, oh, it's going to apply to me without having other elected office. So I think that clarification is important.
So that's exactly the reason for adding it, you're right, Commissioner. So that's what we had previously advised when asked. At present, the definition of contribution already covers contributions to federal, state, and local elections. And so this is really just the logical conclusion of that as it relates to a person who is an officer who accepts a contribution while also running for
Central committee.
Central committee. So you're correct.
Yeah, thank you.
So with regulation 18438.7, that pertains to prohibitions and disqualifications under the Levine Act. And with this proposal, we are clarifying the standard for determining when an officer knew or should have known about a contribution. We're also updating a reference to contribution limit from $250 to $500. Additionally, after further review of the statutory and regulatory language, and in response to a comment by Cal Cities, we recommend removing subdivisions C and D, both of which pertain to the return of contributions, as section 84308 now more explicitly and sufficiently addresses that topic. And then with regulation 18438.8, which pertains to disclosure, since the pre-notice discussion in January, staff has further revised the proposed language to more closely track the statutory language. The proposed language would require a party to disclose relevant contributions before the date that any decision is rendered by an agency. And we've also added a proposed provision that would require an official to make a disclosure confirming that a contribution has been returned pursuant to section 84308.
All right, seeing no questions on that. Moving along now to regulation 18360.1, and this is a reg that deals with the eligibility requirements and considerations for Streamline, Tiers 1 and 2, Warning Letter, and the PrEP program. And really here, we're just talking about some minor cleanup in response to raising of the threshold from $250 to $500 with the recent changes to the Levine Act. So we've made the appropriate adjustments here and also ran it by Enforcement Division, and they support this minor cleanup as well.
That's helpful. So initially, I had some interest in potentially taking a different direction on this regulation. But I think what makes sense here, the previous commission already voted to include these specific violations in the Streamline regulation. As we're going to see in a moment, we have consideration of our streamlined regulations on our regulatory calendar. So personally, as far as I'm concerned, I think what makes the most sense at this juncture is wait until we have a full commission of 5 commissioners. And then when we take up the question of streamlined regulations, at that point, hopefully we can build a consensus as to whether we feel like this should stay in the streamlined regulations as is, or changes need to be made. So as far as I'm concerned, I support this minor change, which essentially just changes, what, 250 to 500?
That's right.
Yeah, thank
Commissioner
you.
Ortiz?
I spent a lot of time reading this point 1 because I really don't understand how do you put something tier 1 or tier 2 or what is the other one? Streamline. I would like to understand it more, and I think we talked about it, that I need to have some training in that as a fairly new person. But the other part that I want to understand is, how do you measure public harm? And that's something that I don't know if, because I'm new, I don't understand it. Commissioner Brand might not know either.
Sure. Excuse me. I think that's a great question. And I think that what we should do is we should have legal division come back to the commission and walk us through the whole process.
Yeah, and the issue of discretion from an enforcement officer, how he or she, is that open-ended issue of discretion? Does somebody else have to approve that issue, whatever? Those kind of issues like that, I would like to talk about it.
I think that's a great point. And I think we do have plans to do, is that correct?
Yes.
Executive Director West?
Oh.
Go ahead.
Yeah, I don't want to read from Executive Director West's notes, but when she previously outlined, when the last, I think it was over a year ago, all the steps to determine whether something is eligible for streamlining, that overview was very helpful, and I think to do that again would be beneficial to especially the newer commissioners, because I found that overview to be very informative. And at some point, I know there's information on our website about streamlining and the various tiers, but to hear the presentations from Executive Director West again would be very helpful.
Thank you. Yes, Executive Director West. We are planning to do presentation. We were hoping for the appointment of our 5th commissioner before this meeting, but we are in bated breath anticipation of that happening soon. And once we do, our plan is to do a streamline extravaganza for you. So it'll probably be multiple parts at different meetings, because what I have found in the past is doing streamlined presentation all at one meeting is a little exhausting for the commissioners. So we might do a couple different bites at it, and then at the end have some great streamlined regulation changes. And everybody will get the training at the same time. So it'll kill 2 birds with 1 stone. I always try to get at least one old-timey expression in at every meeting. So maybe that'll earn me a drink later.
Okay, great. Commissioner Ortiz, do you have anything additional on that? Okay, go ahead.
Seeing no further questions on that, the last proposed amendment we have for the commission is Regulation 18705, and this is concerning legally required participation. So really this is dealing with a public official who has an interest and would otherwise be disqualified, but under this regulation can still participate if there's no other alternative. And again, all we're doing here with respect to this regulation is increasing the threshold in the case where an official has received a contribution over the Levine Act contribution threshold, just reflecting the recent legislative changes.
Excellent. Any public comment on the remainder of the regulations? Okay. I'm going to move to adopt the proposed repeal and amendments. Do you have a second?
Second, the caveats that you mentioned earlier.
Commissioner Ortiz?
I think that you want to proceed in the
Okay.
the things that you propose, the evolution of this in the future.
Okay, that's helpful. So I guess the clear motion is, we're moving to adopt the amendments as proposed. And in addition to that, hoping that we can move forward. And this is more of a direction to legal division and the regulated community rather than a motion for action. That we can move forward with soliciting feedback from the regulated community on how we might be able to best navigate the competitively bid contract issue that you described so well earlier.
So second.
Excellent. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Thank you.
Thanks very much.
Thank you all. Thanks for all your hard work on this. So item number 6, regulation projects and schedule for 2025. And we're going to be hearing from General Counsel Dave Bainbridge. Good morning, Mr. Bainbridge.
Good morning. Back again with the reg calendar. A little late this year. We were waiting for Commissioner Brandt to join us. We thought we might have another commissioner by now, but we couldn't wait any longer. The reg calendar is really just a tentative schedule of the regulations we plan to take up this year. It's built based on input we received throughout the previous year of issues that came about. Some of them are because there's legislation that we need to respond to. Some of it's suggestions from staff. Some of it's from the commission. We even have one from the California Political Attorneys Association. They had an idea that we thought was a good suggestion, so we have that on there as well. I think it's important to people to understand where the sources are. As we go through the year, if commissioners or the public have ideas for regulations, send them along to me. I keep a folder, and towards the end of the year, we look at them and decide what we think is a workable, what we can do and what the priorities of the commission are, and come up with this list. It's not binding in any way. It's really just we want to put a schedule out there so everyone knows what we're looking at, what we're working on. Hopefully we get input from interested parties early on in the process. Always makes it easier for us. And I think it results in a better product. The earlier we have input and the more we can think about things and put them in there. So this is the schedule for this year. Again, it can change. We're not tied to this in any way. It's really just a schedule that the commission approves of, and this is what we plan to do, and things will change, and it will necessarily change through the year. And if we need to add one later on, we can. But I think it's just a good way to go about our business to have the plans laid out in advance. So I won't go through each proposal in great detail. There's a brief description in here, but if there are questions about any of these, feel free to ask them now. And they can evolve over time. We start looking into something and maybe we see another issue that needs to be addressed in the same vein. Or there's even instances where we start to write a regulation and we go, we don't need this regulation, or we can't come up with a good one. We don't think this is necessary anymore. So again, tentative, flexible, but want to give people an idea of what we're going to be working on over the next, 9 months. So I will take any questions if there's any about the specific proposals at this time. I will note for Commissioner Ortiz, enforcement penalties is on there. So we have it on the calendar. We'll get the presentation on how it all works, and then we can talk about what changes we may want to make to the streamlined criteria come September, I think it is.
Commissioner Brandt?
I don't have the specific ones. In other words, I've seen the list, and I'm just, as a new member, I want to understand how this goes, and I think I'm hearing it, is there's some, it may come from a commissioner, may come from the public, may come from staff, it may come from a regulated community, it may come from a variety of places. So the source starts, and then what do you do before it gets, so we have two bites at it. What happens before it gets to us the first time? How does that process work? Just internally, I guess.
Yeah, so it gets assigned out to a specific attorney in the legal division, each project. Sometimes we have two attorneys if it's a big project like you saw with the last one, but typically there's one attorney from the legal division assigned. They start right away with researching the topic, read all the advice we've given on a particular topic, go through the regulation file. If it's an existing regulation, we have files for every reg so they can see the history, why the reg was adopted in the first place. A lot of times you see history repeating itself when you go through the old reg files and see what public comment there was in the past. Get a really good understanding of why the reg is what it is now. You know, the old don't remove a fence unless you know why the fence is there sort of approach to it. So they'll do all the research. We have internal meetings, kind of discuss which direction we think we're gonna go with it. And depending on the regs, some are very clear and some are much more broader topics. We have internal meetings, discuss it, and then they start drafting the regulation. It goes through multiple levels of review. Sometimes the whole legal division will look at a particular draft regulation and give their input and suggestions. And then eventually it works its way up to the commission. Usually the executive director and the chair will review it, and then it gets put on the agenda for pre-notice, which is before we notice it with the Office of Administrative Law, because we have to do that before the commission can adopt it. We bring it to the commission and kind of say, what do you think? What do you like where this is headed? What suggestions do you have? It's also the opportunity for the public to weigh in on what our draft is. We've found it's always good to have a draft in place because it gives us a starting point. But the pre-notice is really the stage where we try to get as much input as we can. We can make changes. The commission can say, we don't like this direction where you're going at all. Let's go a different direction on the regulation. Or they can say, yeah, looks good. We'll see it back here in 2 months. So it really just depends on the topic. After the pre-notice meeting, we make adjustments, changes, and then hopefully have a finished product for you. We bring it back 2 months later because we need time to notice it with OAL, which is about a 45-day process. So which is why we can't bring it back the next month. We bring it back the month after that typically. And that's the final product that we're hoping that we've got everything in line and we just adopt it as it is.
Okay, and then, so I understand, are there, and this may be just more experience, are the cases that we're considering, or the stipulations, are those coming into this process? In other words, the decisions we make, or, and there are issues I've seen in stipulations, there are issues that come up. Are those incorporated? I mean, I guess I should, I know it depends on the case, right? But is that common? I'm just trying to understand the process so I understand where I fit in this process. And I fit in just at the pre-notice piece, right? Or are there times you pull in commissioners to say, we're working on this and you made some comments on, some case or something? Tell me about the process.
Yeah, so on the enforcement question, I can think of a couple instances where an enforcement case maybe has resulted in a regulation. It's usually not one that ends in a stipulation. It's usually one where it ends in getting closed because the law is unclear. So if the law is not sufficiently clear, enforcement will close it and will ask the legal division, hey, we think this area of the law is unclear. Can we draft a regulation that would clarify this point?
Okay.
So that will occasionally happen in the enforcement context. It's more common that it happens from the advice function, where we get an advice question and we go, that's a great question. We could clarify this. Some of our regulations are just a collection, essentially, of advice that we've gotten over time and given over time that we then put in a regulation.
Okay, thank you.
Commissioner Wilson?
Thank you, General Counsel Bainbridge. You didn't look at one note on your notepad as you outlined that process.
You and I have been doing this for a while, so.
Yeah, but I'm only part-time. But anyway, in terms of clarifying the law, and I didn't know if Commissioner Brandt had also thought about this, but to what extent do you look at legislative intent as you're drafting the legislation? I mean, the regulations. Is that a factor that plays into the actual process?
Yeah, definitely. Obviously, it depends on the regulation. Those guys spent a ton of time digging through the regulatory or the statutory history and stuff that really isn't even technically legislative history to draft that regulation. The regulations have to be consistent with the statutes, and to understand what the statutes require, we have to know the legislative history. So legislative history is an important part of what we do for a lot of the regulations, especially when it's a regulation interpreting a new law.
That's what I assumed, but thank you for the clarification.
Now, when it's statutes from the original 1974 proposition, I've been and looked at the legislative history and there's almost nothing. So that it's not much help for the ballot measures, but when the legislature actually passes amendments to the act, there's usually a decent legislative history for us to look over.
Thank you.
Any public comment on the calendar? Okay, hearing and seeing none. I'm going to move to approve this item, to approve the regulation projects and schedule for 2025. Have a second?
Second.
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Okay, let's move on to item number 7, and that's our legislative update. We're going to be welcoming Senior FPPC Legislative Counsel Lindsay Nakano to the table to present on this. Good morning, Ms. Nakano.
Good morning, Mr. Chair, Commissioners. Nice to see you all. All right, on to legislation. There are currently 21 bills that relate to the Political Reform Act that are active now. I'll update the Commission on all 8 of the Commission-initiated bills and all of the other PRA bills that are new since last month. The Commission-initiated bills came from ideas presented to the Commission last November, and I would ask that the Commission vote to support and sponsor all 8 of those bills today. Before I get to summaries, I'll give a quick committee update. The Assembly Speaker adjusted committee assignments at the end of last month, and Assemblymember Macedo is now Vice Chair of the Assembly Elections Committee. All right, on to bill summaries and updates. I'll go over the 8 Commission-initiated bills first. AB 359 by Assemblymember Ramos, which I also briefed the Commission on last month, would repeal the sunset provision on the section in the PRA that authorizes the FPPC to contract with local government agencies to administer and enforce their local campaign finance and government ethics laws. That bill will be heard in the Assembly Elections Committee next week. AB 775 by Assemblymember Fong relates to behested payment reporting. I'll go over some existing law for background and the main provisions of the bill. Existing law requires elected state and local officers and members of the Public Utilities Commission to file behested payment reports. Currently, these reports are due within 30 days of meeting a certain threshold and are filed with the officials' respective agencies. At the state level, the agency is required to forward a copy of the report to the FPPC within 30 days, and at the local level, the agency is required to forward a copy of the report to the local filing officer. AB 775 makes 4 main changes to the behested payment reporting requirements. First, the bill would require behested payment reports to be filed directly with the FPPC using the Commission's electronic filing system for these reports. For local elected officials, there would be an alternate option to file locally directly with the official's local filing officer if all behested payment reports for officers of the local agency are posted publicly on the agency website. Second, the bill would alter the deadline for filing behested payment reports. Currently, the deadline is based on the date the behested payment was made. Officials must file with their agency within 30 days of the payment, and then their agencies forward a copy to the FPPC or local filing officer in another 30 days. The bill would alter the reporting structure and deadlines such that payments would be required to be reported within 30 days following the end of the calendar quarter in which total payments from a single donor reached the threshold. Third, the bill creates a threshold for reporting of additional payments after an initial behested payment report is submitted. Existing law provides that after the initial behested payment report for a particular donor, any subsequent payments in any amount by that same donor must be reported under the same 30-day deadline. Under the bill, subsequent payments made after an initial behested payment report for a particular donor would be required to be reported only after reaching an additional $1,000 from that donor in the same calendar year. These subsequent reports would be due within 30 days after the end of the calendar quarter, consistent with the initial report deadline. And last, the proposal codifies 2 existing regulations relating to additional information that must be reported on behested payment reports and reporting good faith estimates of payment amounts under certain circumstances. This bill is also set for hearing next week in the Assembly Elections Committee.
Sure, I have one comment on this bill. I think it's worth sharing with the public just how, passionate as chair I am about this specific bill and why that is. Because behested payments can be a real complex area of the law, right? What I feel like what this bill is going to do is secure not just greater transparency, but meaningful transparency, right? And what I mean by that is you're going to get timely, reliable, accessible data. And I think that's what the public wants. They don't want to have to file a Public Records Act request with their local city to see if a specific public official filed a Form 803, a behested payment report on that day. That's very tough. That's a heavy administrative burden, certainly on a citizen, even on the media too, right? What they want is to be able to easily just log on to their city's website, go onto their city's website, go onto our website, and have that information at their fingertips in an easy to understand way. And that's what this does. And I think there's just so many reasons why, that's great for public trust. In addition to the fact that it's just going to increase scrutiny in regards to these payments, right? Because when you have greater accessibility, greater awareness, there's going to be a general increase of scrutiny. So I hope we've made that clear. I believe I have, probably too much so. But I just wanted to again thank the author for pursuing this really thoughtful and important legislation.
Okay, seeing no other comments, I'll move on. AB 808 by Assemblymember Addis. This was previously a spot bill, but was amended to make 3 changes to make the PRA consistent with the Cal Access Replacement System that is currently in development. The bill would eliminate filing by fax in the PRA. It would delete references to forms and the definition of campaign statements, and would clarify when certain signature verification is needed for statements and reports filed on cars.
Commissioner Wilson?
Yes, I think everyone here understands what a spot bill is, but if you could just briefly explain for the benefit of the public, that would be very helpful. Took me a couple years working in the legislature to figure out what it was, so.
Absolutely. So for the benefit of the public, a spot bill is a non-substantive bill that makes a non-substantive change somewhere in the law. It could be changing a comma, it could be a grammatical change, it could be something like that. And it serves as a placeholder for the author to substitute that for substantive language later on in the process.
Thank you. Very clear definition.
Okay, moving on to AB 953 by Assemblymember Pacheco. This bill is currently also a spot bill, but will be amended very soon to house the Commission's proposal to prohibit foreign nationals from making contributions, expenditures, or independent expenditures in connection with a state or local ballot measure, consistent with existing law as it relates to state and local candidates. The author's office is including an exemption to the definition of foreign national for individuals who have been granted deferred action under the Federal Deferred Action for Childhood Arrivals Program. AB 1029 by Assemblymember Valencia relates to disclosure of cryptocurrency. The bill would require public officials to disclose cryptocurrency on their statements of economic interests, also known as Form 700s, in the same way that other types of investments are disclosed. AB 1286 by Assemblymember Berner, also a spot bill, but will be amended any day to house the Commission's proposal requiring disclosure of prospective employment information on the Form 700. SB 280 by Assemblymember Cervantes, which I briefed the Commission on last month also, would extend the prohibition on receiving or delivering contributions in the state capitol or state offices or office buildings, and it would extend this to apply to legislative district offices and to local government offices and office buildings. This bill is set for hearing in the Senate Elections Committee on April 1st. SB 852, this bill is by the Senate Elections Committee, eliminates the requirement that the FPPC send manual notifications for bills that seek to amend the PRA, given that an automated notice function for PRA bills now exists on the LegInfo website. As Commission-initiated bills, I'd like to request a vote to support and sponsor these 8 bills after any discussion from the Commission. And if any of these bills are substantially amended later in the year, I'll bring them back to the Commission to affirm or reconsider its position.
Excellent. Any comments from commissioners or feedback on these potentially sponsored bills? Okay. Any public comment? Okay, then I would move to sponsor these bills. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Great.
Thank you. And I'll move on to other commission-related bills. There's quite a few. AB 884 relates to investor-owned utilities and contributions. The bill would prohibit an investor-owned utility from making a contribution to a candidate for elective state office and would prohibit a candidate for elective state office from accepting such a contribution. AB 950 requires that a print advertisement paid for by a committee other than a political party committee or candidate-controlled committee include, actually this is existing law. Existing law requires that a print advertisement paid for by a committee includes specific disclosures, including who paid for the ad and the ad committee's top funders. For larger print advertisements like yard signs and billboards, existing law requires each line of the disclosure to be at least 5% the height of the advertisement. AB 950 would allow larger print advertisements like yard signs and billboards to satisfy the disclosure requirements instead by requiring a reference to an internet website where all of the information required to be disclosed is provided. This means that the payor and top funders would not appear on the face of the ad. It would be like a hyperlink to a website. The bill would also provide that for larger print advertisements, the disclosure shall not be more than 5% of the total copy area of the advertisement, which would create a maximum size limit for the disclaimer with no minimum size requirement. AB 1370 relates to non-disclosure agreements for members of the legislature. The bill would prohibit members of the legislature from entering into or requesting that another party enter into a non-disclosure agreement relating to the drafting, negotiation, or discussion of proposed legislation. The bill includes an exception for NDAs that prevent only the disclosure of trade secrets, financial information, or proprietary information. The bill would also make void and unenforceable any NDA relating to drafting, negotiation, or discussion of proposed legislation entered into after the effective date of the bill.
Commissioner Brandt?
Can you tell me what the problem is? I mean, has there been an incident like this? I mean, it's just kind of, why would a member legislature do an NDA? I mean, other than the exemptions there, what kind of things have happened before that led to this bill?
I'm not currently aware of whether there are specific instances that the author is citing to. I think their thought is that generally if there are discussions happening about legislation, that these should be discoverable, should be publicly available in some form. So NDAs are antithetical to that.
Right. You know, I understand that, I agree. I just can't imagine. Legislator is all in public, and so doing an NDA to secretly develop legislation, I just can't imagine. But that's why I'm trying to find out if there's a problem. But Patterson, Central Valley Patterson.
I believe so, yeah.
Okay.
It's, I think it's Rockland Patterson.
Oh, Rockland Patterson.
Yeah.
Okay.
Because the other, so there's Joe Patterson, Jim Patterson. I think Jim actually has retired.
Oh.
Yeah.
Wow.
So Joe Patterson doesn't have to worry about being called Jim Patterson anymore.
Okay.
I know that was a big pet peeve of his. So I'm going to disclose ex parte with their office. I reached out to their legislative director because I was interested in why they felt like this was appropriate to include in the Political Reform Act, right? Because it's my understanding that this wouldn't be enforced by the FPPC, so I didn't really see a clear nexus. So I suggested that this would not be a natural fit with the Political Reform Act, and we'll see how their office chooses to proceed based on that advice. Any other comments on this item? Okay, thank you, Ms. Nakano.
You're welcome.
Oh, go ahead, Mr. Wilson.
And you may or may not have know the answer to this question, but I think before we as FPPC take a position on this issue, there should be some clear examples that are outlined so that we know that there is an issue that needs to be addressed through legislation. And in the meantime, it's probably best for us to be neutral until we get some additional information.
Understood.
Agreed. Excellent point.
Okay, I'll move on to AB 1511. This bill was introduced by the Assembly Committee on Elections. I believe this one was introduced after the date of the report, so it will not appear in the written report. The bill expands a provision added last year relating to when a candidate may transfer funds raised before the primary election for the general election to a different committee. Existing law permits a candidate who does not file a declaration of candidacy to qualify for a primary election or special primary election, and who does not otherwise withdraw from the general election or special general election, to transfer funds raised for the general election to a committee established for the same or a different office, subject to the attribution rules. This bill, AB 1511, revises that provision to apply to a candidate whose name has not been listed on the ballot at a primary election or special primary election, and who is not qualified to have write-in votes cast on their behalf counted by elections officials for nominations or election to an elective office at a primary election or special primary election. I know that was a lot. I believe this codifies the Commission's advice letter, the Brown advice letter, which the Commission had heard about previously during regulation presentations. Moving on to SB 321 by Senator Cervantes. This bill would create a new 24-hour reporting requirement for late signature curing expenditures related to ballot curing activities specified in the Elections Code. And I've reached out to the author's office for more information on background on this bill, and we'll keep the Commission updated. SB 401 by Senator Hurtado. This bill is an intent bill. It may be amended in the future to make substantive changes. SB 458 by Senator Nielo would require the legislative analyst, instead of the Attorney General, to prepare ballot measure titles, summaries, and financial impact estimates contingent on approval by the voters of a companion bill that makes similar changes in the state constitution. This bill is a reintroduction of SB 858 from 2023 and was just set for hearing in the Senate Elections Committee on April 1st. There are two remaining bills. These are easy ones. SB 760 by Senator Allen and SB 817 by Senator Choi are spot bills and intent bills, respectively. So those bills may be amended in the future to make substantive changes.
Commissioner Wilson?
No, I was just saying if she says it's a spot bill, it's a spot bill, so.
Excellent. Anything additional on the legislative update?
That's all for me.
Thank you, Ms. Nakano. Any comments from commissioners? Do we have any public comment? Okay. Thank you, Ms. Nakano. Why don't we move on to our next item, which is item number 8. That's going to be our executive staff report. So we're going to start with our assistant enforcement chiefs, Angela Brereton and Christopher Burton. Or Chris Burton. But what do you prefer?
Either works. Thank you.
That makes it easy.
Thank you, Chair and Commissioners. Today, the Enforcement Division report is as submitted, but happy to answer any questions that you might have.
Sure. Any questions from commissioners? Okay. Thank you. Any public comment on that piece? No. Okay.
Thank you.
Thank you. Ms. Shaw. Good morning.
Good morning, Shraddha Shah, Chief of Audits and Assistants. My report is also as submitted, but I'm happy to answer any questions.
And it looks like we had the public draw last month?
We did, yes, the first one.
Okay. That's good for the public to know. We have Commissioner Brandt.
So I just want to understand how, I mean, touch on a lot of different things and you have to cover a lot of different things. How do these things develop typically? I mean, how do audits, in other words, there are ones you're required to do, there are ones that, you know, that are due, but how do these things typically come up? I'm just trying to learn as the new member, how do the audits, and so it's not necessarily about specific ones here, but can you tell me a little bit more about what your experience has been?
Yes. So we have mandatory audits, which are clearly listed in the law.
Right.
And those we have to do. Those either those are selected based on their threshold or we do a public draw, which we did the first draw this year. Draws are conducted 3 times during the during odd years. So for 2025, there was one in February, there will be one around August timeframe and one later in the year. For discretionary audits, those are either we get directions from the commission, from executive director, or we see something that requires an additional audit. So those are done based on those criteria.
Can you tell me about the ones that you select, that you identify? How do those typically come up, and how do you make judgments about, and do you have enough resources and all those kinds of things? How do you make judgments about how you get to which audits?
For discretionary audits?
Yes.
The last one we did was the one that I had reported on last commission meeting. It was the 807, Form 807 audit. That one came up as a result of an article that was published in the Cal Matters newsletter. And based on that, we decided that there was a need to look further into the area. And we got directions from the chair, from the previous chair who was here at that time, and our executive director to go ahead and start a discretionary audit in that area.
Okay, thank you. That's it. I just wanted to understand how that happens. And you're auditing staff, you potentially are auditing how the commission is doing things, the commission itself.
No, we audit campaign finances.
Okay, right.
We do not audit agency staff.
Okay, yeah. Okay, yes, thank you.
So Executive Director West, maybe you can speak to that point. Who would be auditing or considering staff activity? That would be more of an administrative division role. Is that fair to say?
Yes, generally I take care of making sure that there's oversight, making sure we have the proper amount of managers, supervisors, they're trained, we have all of our policies, procedures in place. I work closely with Ju Wang and Dave Bainbridge in order to make sure that we're all in coordination and when we identify places where policies need to be implemented or procedures need to be put up to the commission level, then we go ahead and do that.
Thank you.
Great. Well, thank you, Ms. Shaw. Appreciate that.
Thank you.
Let's move on to the legal division. General Counsel Dave Bainbridge.
I'll just point out so that people are aware of it, because it can kind of get lost in this report, the section on new and updated educational resources. So every month, if we have something new on our website, we post a link to it here. So for this month, we have a fact sheet we put together about behested payment reporting, particularly aimed or motivated by the fires in LA and questions we received about concerns about what the behested payment reporting requirements would be for public officials that might be asking people to make donations to charitable organizations to help out. So we have that fact sheet on there, and each month, whatever is posted that month is listed here.
Excellent. Thanks for pointing that out. Okay, any comments on legal division report? Perfect. Why don't we move on to administration and technology division? Dr. Wang. Good morning, Dr. Wang.
Morning, chairs and commissioner. Admin report submit as it is. I just want to highlight one thing, because this year is our first year for mandatory e-filing. So we just passed our March 3rd deadline. So the data based on as of March 6th, we have 97% filer file on time. We have 58 non-filer, which is 2% of the total. So I have the same table run last year the same time. So compare the last year, same time, we have 92% filer file on time, and we have 170 non-filer, which is about 7% of the total. So that gave me the conclusion is, so this year, on-time filing rate has increased by 5%, and the number of non-filer has decreased for 5%. So that's our first year mandatory e-filing for March 1st group.
That's excellent. I'm just so glad to hear that because this is something, both of us, a lot of us here at the commission have been working hard on for months and months and months because we knew there was going to be some amount of pushback related to a big change like this. Going from filling out something by hand to filling it out on the computer, there's always going to be friction. And I think your unit did such a good job ushering public officials through this big change, and such a good job that we didn't see decreases, right? We saw increases in timely filings. So I just think that's so impressive, and I just want to thank you and your team for being so patient with everybody. I'm sure you got some unfortunate calls where people were frustrated, and you dealt with it excellently. So thank you.
Thank you. Yeah, we are ready for April 1st. So.
Perfect. Any other comments from commissioners on that point? Okay, Executive Director West.
Hello, one final thing. We have our annual report attached to the agenda this month. Please peruse it, and you will also see a shout out to our SEI unit who got us over, as well as our IT unit, all within admin, that got us successfully transitioned to e-filing. And you'll see the other activities of the commission throughout the year. I would like to thank our executive fellow, Eva Hartman, and our senior legislative counsel, Lindsay Nakano, and our IT specialist, Rieko Ivaska. And I want to especially thank those three because they are the ones that made this annual report happen, and they put on all that time and energy, and it is beautiful, and it has really nice pictures and graphics, and so I encourage everybody to read it and enjoy it because it's all the great things the agency's done this year.
Commissioner Wilson.
Just for a point of clarification, it's also available not only on the website, but it was also printed as well, a limited number of copies, correct?
I don't believe they're printed yet.
But
okay. They are printing.
Printing, okay.
So if you'd like one at the April meeting, we'll make sure to have those.
Okay, yeah, it's always an excellent report, so thank you.
Agreed. And I think one thing just to quickly run through, number one, I just want to thank the prior Chair Matich, for all the hard work that he did and the commissioners that worked with him for the commission to have a successful 2024 and the previous years or the years prior to that. And we covered some of the significant achievements that were secured during that period during his tenure. Also want to lay out 3 different achievements that the commission secured in 2024. Number one, we successfully prosecuted over 1,000 cases, resulting in over $800,000 in administrative fines, right? And that's a record going back to 2017. So I think that's definitely worthy of highlighting. Also, we expanded the nationally recognized PREP program, Political Reform Education Program, which is allowing the FPPC to prioritize enforcement resources on prosecuting the most serious violations of the state's ethics rules. And lastly, we secured a major legislative victory to increase transparency in the digital age, which we just mentioned, which was this critical transition from paper filing to electronic filing for the most powerful public officials in the state of California. And we're hoping that we can do a very similar forward-looking transition for bastard payment reporting. So with that, just thank you again to staff, commissioners, for your hard work in 2024. Okay, looks like we can move on to item number 9, commissioner comments and proposed future agenda items. Any comments for future agenda items, anything? Okay, quickly, I just want to make sure I get some additional ex parte disclosures out there that I didn't mention before because we were flying through this. One, Ms. Nakano mentioned that there is a new vice chair of the elections committee. The new chair was nice enough to invite us to meet with her, and we walked through our entire legislative package. She was very generous with her time, and I want to thank the vice chair for offering us that. I also want to mention that we had discussions with Common Cause. I had discussions with Common Cause. Staff had discussions with Common Cause, specifically Sean McMorris, on the behested payment bill that we've been discussing here, as well as the 84308 regulations that we've talked about. So that's all from me. Any additional comments from commissioners? Excellent. Then I'm going to move to adjourn.
Second.
Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz.
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
meeting adjourned.